Let's call the meeting of the fiscal court to order. Welcome, everybody, this morning. John, and I hope I'm saying this right, John Ehrig?
That's close.
Is that close?
Close enough.
How are you?
Fine this morning, sir. You?
I'll let you know after you quit talking to me.
Okay.
We've been down here about 12 years where we're living at right now. And this road we live on, Lauderdale Lane, when we first moved in down there, it didn't even have a name on it. And they wouldn't put one up. And anyway, it just washes out every time you turn around. And
It's almost impassable.
Where is Lauderdale Lane?
It's off Green Acres.
off of Green Acres.
Oh, yes, okay.
And it's a gravel road. but-
I understand. That's not in our road program.
Yeah.
But you got
that's
a
what
green
we-
sign up.
Well, I've
I
talked
don't know who
about,
put it up, but we didn't put it up, did we?
It's a
Right?
forest.
It's a
No.
private road.
I mean, we've got, there's a bunch of green signs on people's driveways and private roads and
well, the problem we're having is I've made about 60 phone calls to try to figure out who owns this road. Because his house is not the only residence on this road.
Right. In
And-
fact, I think this came up again
Yeah.
one time, Mr. John. I'm not sure when.
Yeah,
Bob,
I
do you
went over
recall?
there and, yeah, looked at it. It's been, I don't know, maybe a year ago.
Yeah. Go ahead, John. I'm
Oh,
sorry.
that's okay, no problem. Anyway, there's supposed to be like a culvert down side of the road, but you know, they keep out so water run off. Well, it's all blocked up, and neighbor out there, he gets his stuff away from his fence and stuff, pushes right down into where it's supposed to be a culvert, and just brush and everything in it now. And when that water, we get a lot rain, you know, which, you know, comes down through there and starts washing away, way up by his property. And then it comes down through and just washes all mine up. 2 years ago, we put about $2,000 worth of gravel in there. Now it's just all over the place, and I'm too old to be putting that kind of money into it. I'm retired. And
How many people live on that portion of road that does not belong to the county? Do you know right off, Mr.
Three
John?
Sure.
residents. Three.
Three.
Three, yeah.
But their part of the road is okay, but then where you go down to his driveway, it's like a incline, and it starts on the left-hand side and then goes across the driveway and down the right-hand side. So he's 76 and my mom is 75. We just had to put her in a nursing home. And last year I was here taking care of her, and I literally had to hike out to the road because you couldn't pass it.
We had a
for
hard time
11
getting
days.
paramedics down in there,
Yeah,
and
for
even
11
the
days.
sheriff department, hell, wouldn't even come down in there a couple times because afraid they'd get stuck.
Yeah.
They brought their four-wheelers out there and got in, but
They couldn't get out to get groceries or anything. And I've made about 60 phone calls and nobody can tell me who owns this road and
I
who's
believe last
responsible.
time this was brought up, I believe the guy that, John Daniel Clark, I believe, is the one that done the work. But I believe the guy that owned it has passed away.
well,
I mean, is this platted down in the, is it, that subdivision? I mean, somebody has to have ownership. Is
Well,
there still some
I'll-
undeveloped property in there?
Well,
nobody
Carl-
takes ownership. I went over to the road place there about a week ago, and well, they keep telling me it's a private road, no nothing we can do about it. Well, if it's a private road, I said, who's it belong to? And he said, people live on it. And I said, well, nobody lives on the road. Does it be blocked up, wouldn't it? I mean, he got kind of sarcastic with me, so I just got back with him. And if it is a private road, who's supposed to be taking care of it? Us people like us that ain't got nothing to do with the road except get back and forth. There's supposed to be two cul-de-sacs down in there. Carl Levitt got one of them for his boy, and he built a pole barn up in there. Across the road, Massey lives over there, and that's a cul-de-sac, and they just found out here about 2 weeks ago that wasn't a driveway. That's supposed to be a cul-de-sac up in there. And down where mine is, I don't think there's supposed to be a cul-de-sac. It's just dead end. Mine goes back into the woods, and I own the woods back in there. And in any case, I want to know if something can be done about this, or if it's a private road, what can be done about that? I mean, us just keep fixing, putting our money into it, letting them wash down through there, and neighbors don't seem to help. They just cut their limbs and stuff, and with the dirt running out of their yard down from the pasture and stuff, it just covers it right back up.
It
So I think
washes
something
out.
ought to be done about that. If there was a runoff there, where it go down into, where the runoff runs around my property, it probably wouldn't be doing that.
It washes out literally every time it rains. It's almost impassable every time it rains.
Now when we're going in, now just nothing but mud, and
It's about
I'm
this
too old to
deep.
be down there shoveling dirt and stuff like that, and paying money out of my pocket, so fixed income, when you get, well, I'm 76, so,
Well, let me let the county attorney, on the legal responsibility, it is against state law for the county to put any equipment, do any work on roads that are not part of our road system. Now, when that section of that subdivision was built, the person who built it knew what our regulations were, chose not to comply, therefore, we never took that section of road in. So as a result of that, and Jeff, correct me if I'm wrong, we're in violation of state law. If we come, because you're not the only situation. We've got other roads, subdivisions that people have put in, told the people, when I sell the lots, the county's gonna take it over. That's not true and hasn't been since back in the 70s. These regulations were put in place for a reason. And that, more than anything else, was for the protection of the homeowner. But unfortunately, from time to time, and we've got, Bob, this is not even the only one in your district, is it?
No, got Tanglewood, of course, same
Tanglewood's a prime
situation.
example. So, Jeff, you wanna,
Well, you're accurate. I mean, until it would become a part of the county road system, you couldn't maintain it.
Can we help them find the property owner so that maybe if they want to
What
pursue
they would
it?
need to do is have an attorney research the land records to show
Okay.
who owns what.
Okay.
well, I guess the people, the guy did own the subdivision, he's the one who built the subdivision.
Smith is his name, but anybody know how to find him?
what's his name?
Smith?
And it may fall back on the property owners to, I don't know.
Well, okay, if it's private property as it stands right now, what can I do about it? Block it off? Private road, they said it's mine.
Well, there are other people that use it.
Sure. Massey's and
There-
Lyle Levitt and his boy
Well, I
lives
mean-
back there
Yeah.
too.
I mean, I don't know what the
I know
deeds say
some of
or
these people out in there, they get a lot from the county. Like
Their
rock
section
alongside
of
the road so there's, don't wash off.
Yeah. Their section of
And
road
there's
is
other
straight,
ones out
so
there
it's
that got
fine.
advantage from the county. And all I want is leveled off and a drainage dug down the side and so it won't wash my drive out every time. My wife's got Alzheimer's and dementias and we just had to put her in a nursing home. In fact, we gotta go to court this afternoon for that. And she's been that way for about 7 years now, a little over. And now I'm getting agitated. So with her in the nursing home right now, there's something, I don't know if I can do anything or not, but that's a private road and they say it belongs to us. I guess I got a right to do what I want with it, right?
Well, that would be, you.
Without
I
getting in
get that.
trouble,
I
without
can't
getting
tell
in
you
trouble.
that. I can't tell you that because I haven't, I'm not.
You're attorney, ain't you?
Well, yes, sir, but I don't represent you. I represent the fiscal court.
Okay.
And that is a private, I can't advise you on that. That
Okay.
is, that's a civil issue between you and the other property owners.
Okay, ask me this. What's a private good I mean by private drive other than neighbors are supposed to own it? What do you guys consider a private road?
What do I
Private, yeah, I'm all right, what the court decides. If that's a private road, it's a private road, that means that's part of mine. And most of that's on my property anyway, except for Carl Levitt and his boy, and he owns the other side, and he's the one putting all the brush and letting all the water, dirt run down in there. I mean, I don't care who you are, if that's my property and I got a right to it, I
That's
can do something with it, right?
That's something you all have to work out in a civil court. I can't answer that for you.
Well,
So basically,
So-
there's nothing you can do.
basically,
Well, I
that's what
mean-
you're saying. You can't come out there and dig a culvert down through there and,
Not on a private road, no.
How do we get it a county road then, if it's our private
There's
road?
a petition you can file that have to be brought up to county standards,
Mm-hmm.
and then for the court to consider.
Well, they say, I got a letter at
This has
home.
been the case for years and years.
Well, it's wrong.
If the court is brought, well, it may be
You know,
wrong,
you have
but
elderly people out there and you
I
can't even get
understand-
help to
I
them.
understand, but people don't take into account when they build or buy a piece of property, they need to find out, is it a county road? Is it a private road? Do I own the road or does the county own the road? Now, to be a county road, and we'll be more than happy to consider it if it's brought up to our standards. And when I say brought up to our standards, we have a whole list of subdivision regulations before the county will take it in. I mean, we dealt with one, we had a public hearing just last 2 weeks ago on a piece of property or a road that had to be brought to our standards. They had to give more.
I got one of
right
these
away.
right here at home.
Huh?
I got one of these, well, maybe it ain't the petition, but I got some of the literature says on some of
Yeah.
those pages there. And, I don't care how you look at it. But if it's my property, you know, like you said, it's people out live out there, and I almost that private road, what you're saying. That means I can go down there and put a building on it or whatever I want to. It's private, it's mine, right?
Well, as far as we're concerned. Now,
As far
what
as
you
you're
and your
concerned, that's
neighbors
right.
do,
I don't
That
think
is
nobody's
not-
gonna come down there and try to claim it.
I wouldn't think so.
No, I don't
but,
think so neither.
I mean, what you do on your private property,
That's private property, what
This
you're
court
telling me.
can't authorize you to do anything.
I'm not asking you all to write it.
Okay. That-
We're just
well, that's what
asking you
it
to
sounds.
tell us how we get this settled, because I've called 60 times
I
in
will
Bettman.
have an
I've called
attorney
the ball,
research the records to see who owns what.
I've
That's-
called the
We know
ball,
who owns it.
and if he's
The one
dead,
that
then
built the
what?
subdivision.
If he's dead, then what?
Well, that would be the person that can answer your questions. As
Because
far as
when I
what you
first,
can do.
when first moved out here, I inquired about all that, went down to the deeds, you know, where the property is and stuff. and He still owns it, unless he's dead, so I don't know.
Because he didn't build the house back there, he bought it.
Now
It was
Carl
already
just bought
built.
that, piece of property across there, where his boy built that pole barn, and, that was a cul-de-sac. How'd he go about getting that cul-de-sac? Go to court?
he didn't get it through us. We didn't give anybody permission
Well,
to do
okay,
anything back there.
he's building on property that don't belong to him then, because that's supposed to be a road there.
Well,
That may be true.
may be true, but it's not a county road.
So we just,
So if I'm gonna get involved, I might as well get the whole neighborhood involved, that's the case.
Well, I would say that would be a good idea,
And
you know, to, particularly those that live on that section of road that is private road.
Well, okay, if he's cutting his, side of his property to the private road and pushing it down in there where there should be a drain off there, ain't he in the wrong?
That's what you need to ask your attorney and have him research it.
so he's got to pay a bunch of money to,
Well, I don't know how much it costs, but.
you know how much attorneys cost, you are one.
Well,
You know,
that's the-
he's gotta
if
pay all
you
that
want
money just
Legal
to-
advice, that's where you have to get it.
And that's all they're gonna give me is advice, right?
Huh?
That's all they're gonna give me is advice, right?
Well, I don't know. That would be between you and them. It wouldn't have anything to do with this court.
Well,
Okay,
I thought
Thank
at
you.
least you'll be kind enough to go out there and dig a trench down through there so it quit washing it out. That's not too much to ask, it's probably,
That's illegal.
that's illegal.
Yes.
There was one there before.
Well, I
Before
don't
they
know who
started
put it
putting
in.
all this.
The county didn't do it, though. County can't go on private property.
Well, wait a minute. When they put all this wire and stuff in out there, that's when it got really messed up, you know, for telephone. Now, and it really got messed up out there. And they didn't do a very good job of, you know, redoing the back the way it should be. And I thought that's the way when they put something in, it's supposed to be put back the way it was.
Maybe.
I mean, maybe, you're a lawyer. You ain't gonna give me no answers?
let's
Well,
just
I
leave it
ain't.
at-
Okay, I can see you ain't, you guys go get me an attorney, that's what you're trying to tell me, right?
Thank
Well,
you.
I was gonna try to answer your question, but.
Okay, answer my
You'd
question.
rather insult me than.
No, I'm
do
not
that.
gonna insult,
That's
or you're
fine.
insulting me by saying, well, you gotta go get an attorney, and I've asked you some question, and you won't give me a direct answer.
Well, I've given you every answer I can. I don't have anything to base an opinion on, sir.
Okay.
It has to be researched.
Okay.
I can't tell you who owns what. I haven't even looked at the first deed.
But as
But
far as the West Kentucky telephone, you're saying they did some work there?
they sure did.
Well, see, that
They come
there
right up through
again.
my property and brought it up back of my house, because I sat back in the woods, and they dug up through that, and they took some kind of a grader and plowed that and plowed it back on the backside of my property. And
Again,
they
that's
they didn't take it hauled off or nothing, it's still there.
That's a
So-
private company doing that. I don't know.
Okay,
We don't
everything
own
private,
Kentucky
right?
Telephone, we don't have any stock in it. That's a co-op.
That's co-op. Okay. Well, I'm not a southern boy, but I'm a Yankee, so I'll see what I can do about it.
All right, sir.
Okay, thank you very much.
Josh?
Thank you, Judge. I've got a couple of things for the court. First of all, to follow suit with Randy and the Tourism Commission, I thought I saw right there it is. We would like to, part of the branding study that Randy's already explained it to you guys, was that maybe we consider a name change as far as the Chamber of Tourism and Economic Development. We're not created by an ordinance or anything, but I don't want to make any changes without first getting you all's direction. So I guess one of the things I'd like to get done is to see if you guys would be okay with us, instead of referring to ourselves as Marshall County Economic Development, if we could refer to ourselves as Kentucky Lake Economic Development, to give some consistency to the results of the branding study and with Randy and move forward with that. So how do you guys feel about that?
I think it'd be great.
And we could even do Kentucky Lake and Marshall County. I think is that what you guys are, you're full on Kentucky Lake? I got no problems with that.
We'll find out.
Okay.
Well, the only problem you might have, Kentucky Lake serves more than just Marshall County.
Right.
I
think
mean, you've got
Randy-
other counties involved, and if we use Kentucky Lake, I would like some way to keep Marshall County in there.
The way we have on our website, the way we've got our name displayed, and even on our cards, we can incorporate Marshall County in there, and that's no
I think
problem.
I don't think we need to leave that out.
Okay.
As far as our economic development, there's more to it than Kentucky Lake.
Sure. Okay. Well, if that's okay with you guys, I know we put a lot of money in this branding study, and I certainly want to play.
Well,
Well, I want to
want-
use it,
We want to
absolutely.
use it, but I think Marshall County name has got to stay in some form.
Okay. So what we'll do is incorporate Kentucky Lake and Marshall County into our name and go from there. And really we'll just be using marketing pieces, our website, and on our business cards and stationery and things like that. So anyway, I just wanted to address you guys about that.
Now, Wendy is in
Yes,
today.
she's in Lexington today, sitting in on the workforce or work ready certification presentation that they're giving today. We finished our letter of intent yesterday, and we've submitted that. We're looking at shooting for our certification in September. There are some issues with this certification. First of all, this certification, I don't know how much you guys know about this. This was created by Kentucky County for Economic Development, some partners with workforce development, things like that. We started talking about this about a year ago, Judge. And we met with some adult education people, some folks from Murray State University and the board office, and some industry folks. And we all sat right here in this room. One of the problems we had at the time was we didn't meet the graduation rate criteria for the program. It was some kind of formula that they used to determine what that CAC had to be and what it had to be there. Well, they've since changed that. And we knew
They've changed the threshold.
Yes. We knew they were going to change it at the time. It was a matter of them getting it done. They've changed that, and we meet it now. There are plans that we have to put in place to raise that over a number of 3 and 5 years in order to get the certification. The biggest challenge that we have is the NCRC percentages in our county. This is like a work skills assessment. I think it used to be called Work Keys. Used to be able to take it there in the mall. I know myself and probably 150 other kids in my graduation class went to take it after we graduated. It was kind of part of it. At that time, it was, in order to get it put into the doors of plants, you had to take this assessment and go forward with that. The problem is, that work, I don't know who had, I guess it was Workforce Development that had that, Bob, I'm not sure. They didn't track where the individuals were that were taking that certification. So we have no data that gives us any information as to how many people from our county have taken that assessment. Currently, I think we may only have, Bob, correct me if I'm wrong, maybe 1 or 2 plants in Calvert that actually use
Yeah, I'm
the
not sure.
NCRC,
Yeah, I
including
don't
West
think-
Kentucky Tech, and it's
Yeah.
a very small percentage. Again, with that, we're able to obtain those numbers, but we've got to make sure we request them, because if not, well, they've got to go back and look that up. So all that said, I believe the threshold we have to meet is 9% over a 3-year period, 15% over a 5-year period. We're at maybe a little over 2.5% right now. Nobody in the purchase meets that criteria. Matter of fact, only one, McCracken County is the only county in the purchase that has applied for the certification, and they've just gotten the certification in progress, which is probably what we'll get. But anyway, broadband availability, we meet that. There's some educational attainment criteria that we have to meet that we can set forth and put in place. We've identified a large group of people to be a part of this team. This is not something that Wendy does. Wendy does a lot. This is not something that Wendy can do by herself. This is a community effort. And if our players identified on this team can't all come together and help us come up with a plan to attain this, it's going to be very difficult for us to do. There are a lot of counties, a lot of economic development agencies that are not doing this. These NCRC tests cost money. It costs the plants money. It costs an individual money to go take this test. This certification doesn't offer any kind of funding for that. So we're going to be in a situation where we may be asking our plants in Calvert, to look at ways that we can make sure we get these certifications. So it puts us in a really difficult situation. But nonetheless, we're going to move forward with it and try to at least get the certification in progress so we can work toward that. Like I say, I've talked to other economic developers in the state who have no interest in doing this. They're more concerned about their site, energy costs, things of that nature. But we're going to move forward with it. The other thing, moving into that, we can get all kinds of certifications, labels and everything else, but if we don't have an industrial park, we've got nothing to market. I talked to you guys about that during our budget meeting, our budget workshop. You guys approved $100,000 for us to spend on industrial park development. I'd like to begin the process of talking with you guys about putting out a request for proposals or qualifications from firms so that we can start looking at getting all that data together. We need somebody to come in and tell us where the good sites are, where the wetlands aren't, where the floodplain's not.
What about the money we've already spent through the Riverport Development Authority? Hasn't a lot of that already been done with the phase 1 and 2 studies?
For that,
For that particular
for
area?
that particular area, right. And one of the problems, Judge, is on the riverfront, we've got a lot of private property, and the property prices are escalating almost by the month. It makes it hard for us we own about 50 acres there on the P&L Railway. And we're doing a lot of work to McFarland Road to get that ready for industrial traffic. We're working on a project now that, if it materializes, will be a tremendous project for this county, for this region, for the whole southeastern region. But we're in a situation there, Judge, where, it's hard for us to market, as we've seen in the past, at least with the Riverport. It's almost impossible, if not impossible, to market somebody else's property for them, especially when it comes down to attracting a project here and then nailing a price per acre on that property. It makes it really difficult for us to do that, and a lot of projects fall through in other areas because $6,000 an acre all of a sudden becomes $25,000 an acre, and that project goes elsewhere. So more and more across this state and across other states, communities are vesting themselves in industrial parks. They need the product to market. A lot of them, there's different ways of approaching it. A lot of folks get into spec buildings, but we've tried that in the past. I think spec buildings are great if you can afford it, but you have to have a plan. It's hard to have 5 acres with a building on it and bring someone in. If they don't like that, you don't have anything else. It's a lot better if you have 5 acres and another 150 acres, and if they don't like the spec building, you can offer them something else. That's how we incent companies to come here. It's through real estate, it's through product. We're able to structure deals more so that way than working with what we have now. So I'd like to do this the right way. I'm assuming that what we'll do, Judge, and I've got a template for requests for qualifications. I assume it's pretty standard. That would allow for, there's some, I have to go through and refine this, but I just wanted to address you guys about this before I move forward with it. So I don't know how much the initial studies will be. I would assume anywhere between $20,000 and $30,000, but it will take time. $100,000 isn't going to get us an industrial park, but I think it'll get us started in the right direction. So anyway, Judge, I don't need you guys to take any action. I just wanted to talk with you about it and let you know that I appreciate what you've given us, and we want to certainly be good stewards of that. So,
All right, thanks, Josh.
Josh, I don't know if you know, TBA's putting on a class, 23rd and 24th,
yes,
Bowling Green?
yeah, I will be
Okay.
there.
Okay.
All right, anyone else here, excuse me, to address the court? Let's move into correspondence from the Association of Tennessee Valley Governments. We have been a member of that association since its inception. So thank you for your membership in ATVG, for your commitment to our mission and program of work. Your membership helps to make our strong collective voice even stronger as we continue to represent the interests of the Tennessee Valley local governments, and we strive to find solutions to critical issues that affect us all and provide you with the best service and programs possible. We appreciate your support. Mike Arms, Executive Director of the Association of Tennessee Valley Governments. We serve in ATVG 7 states and 201 counties in the Tennessee Valley. I served as president for 5 years of the association, and they work diligently with the TVA board and on behalf of local governments. From MediaCom, the purpose of this letter is to inform you that on or about September 1st, 2014, MediaCom will be changing the seasonal rates for some of our services. The new rates are as follows: video only, the current price $7.50 a month, new price $10. HDS only, $10 a month is the current price, goes to $12.50. Video and HSD, $17.50 a month, currently will go to $20 a month. These rates are for customers who keep service using standby rates while away 2 to 6 months. MediaCom appreciates the opportunity to continue to serve your community's telecommunication needs. If you have any questions, don't hesitate to contact me. This is from Kate Hoddle, the Manager of Government Relations. It is time, Jeff, I think I put in your, we'll have this for the next agenda, but next meeting, but it's
Okay.
time to renew our franchise agreement with MediaCom, and they've sent us a contract, and I gave it to Jeff to review, and we'll take it up and try to make copies for you guys before the next meeting.
Before you accept a franchise agreement, it has to be advertised for bid.
Yeah, that's true, and we've done it every time and get one bid, but I think it's statutorily, we have to do it.
Yeah, we had to do the same thing for Hardin. We're doing
Yeah.
the same thing for Hardin, so.
Okay, we'll get that done. From the Department of Transportation, this letter is to inform you that the Kentucky Transportation Cabinet's draft FY 2015-2018 statewide transportation improvement program will be available for public inspection at your local highway district offices, area development district offices, metropolitan planning organization offices, and division of planning of program management. It will also be on the KYTC's website at transportation.ky.gov. To comply with federal law, KYTC is making the FY 215-218 draft available to the public from Monday, July the 14th through Tuesday, August the 12th, a period of 30 days. Any review or comments you have may be submitted to Steve Waddle, State Highway Engineer, 200 Metro Street, 6th floor, Frankfort, Kentucky. From the Kentucky Conservation Officers Association, they are asking for our help in buying, I guess it's a half-page ad in sponsorship of the Kentucky Conservation Officers Association. It's $450. This goes to conservation groups throughout the state. Some of the things, they have a Muhlenberg County equestrian program, God's Great Outdoor Youth Events, archery program, Fishing for Smiles organization for handicapped children, and youth hunts. They're asking each county to contribute. I just told them I'd bring it before the court if you want some time to think about it, or this is something we did not budget. I just got the request yesterday, so if you want to just table this, we'll
Table it.
give you time to look at it. Okay. All right, let's move into old business. You've all received the minutes of the July 1st meeting of the fiscal court. Are there any corrections or additions to the meeting, minutes of the meeting?
I have none. Motion to approve the minutes, Judge.
We have a motion to approve the minutes. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Next is the second reading of ordinance 2014-06. The fiscal court of Marshall County, or Marshall, Commonwealth of Kentucky, at a meeting to be held at 9:30 local time on Tuesday, July the 15th, 2004, in the Joe Williams Fiscal Courtroom, second floor, 1101 Main, Benton, Kentucky, will consider for passage the following ordinance. An ordinance officially changing the name of the Marshall County Tourist Commission to the Kentucky Lake Convention and Visitors Bureau. A complete copy of the ordinance may be reviewed at the County Judge Executive's Office, 1101 Main, Benton, Kentucky, during regular office hours. We had the first reading at our last meeting. What is your pleasure?
Motion to approve, Judge.
We have a motion to approve. Is there a second?
Second.
Motion and second. Any discussion on the motion? Hearing none, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. I guess we better have everybody sign
since we're changing the name of our tourism bureau,
Right. Oh,
a few years ago, we looked at trying to expand a boat ramp up in the Ken Lake area, somewhere around there, and it never did go anywhere. It seems like we've got an area there that we have the tennis center. It's not used very effectively. Is there something that we could begin to look for funds and that sort of thing? If you could come over to the speaker.
Here's the situation that came up with the boat ramp, and I'm sure you'll notice. Where they wanted to do the boat ramp was over near the old beach at Ken Lake.
Yes.
A portion of it. To do that, they had to get the Kentucky Department of Parks to give that land to the Kentucky Department of Fish and Wildlife. Well, Kentucky Department of Parks did not want to give that land to Fish and Wildlife because it contained the gazebo area as well. So they never could get the two organizations to agree on a trade-off to have that ramp.
That's just a bureaucratic
It's
stumbling block that a
exactly what
tourism
it is.
director could
Well,
work through.
I will do my best. I will talk to the commissioner.
But honestly, I'd like to bring that back up.
I would too. We
It's
need something in that area that would help. And that's one of the things that can easily be done. And not
Tournaments,
only there at
the
Ken
fishing
Lake,
tournaments really bring in a lot. And anyway, I'm being told by fishermen and people that deal with this that that's an ideal area.
It is.
But we're losing tournaments to Paris Landing and that sort of thing because we do not have the ramp, the area as where they can easily get in and out. Number
Yes and
one,
no.
and then that building there is perfect for them to set
We-
up with and do weigh-ins and that sort of thing.
In Marshall County, we have 3 ideal spots for fishing tournaments. And I'm not showing favoritism to anyone because any resort that has a marina, if they want to show me their weigh-in facilities, I'll add them to my list of 3. Kentucky Dam Marina, Moore's Resort Marina, Ken Lake Marina. Ken Lake's big issue is parking. There's not anywhere to park a boat there. The ramps are good.
That's correct.
Parking's horrible.
But over there where we're
There's plenty of
contemplating
parking.
this, there's tons of parking.
The issue with us losing tournaments to Paris Landing is not our facilities. The issue with us losing tournaments to Paris, Tennessee is financial. When you have BASS Elite Series tournaments that sends a proposal to Marshall County wanting to host one of their elite events, and it's a 6-figure bid fee, they want us to pay over $100,000 to get 91 anglers to come and fish for 3 days. My entire fishing event budget is $65,000 a year for all fishing tournaments. So they priced us out. Paris is paying it. How they're paying it, I'm not sure how they have their funding. I just agreed yesterday to do a tournament, which I can't tell you what tournament it is because it's secret, but they called me wanting to come here because their anglers do not want to go to Paris, Tennessee anymore. They don't like fishing out of Paris, Tennessee. The problem we have is if a tournament, and I'm just going to use them as an example. If FLW comes to me and says, Randy, we want to bring an FLW tour event to you next May, and it's going to cost you $30,000 to get that tournament here. My budget may be shot. We may already have 60 of my $65,000 out there, and I have $5,000 left. Well, Paris Landing, how they're getting their money, I don't know. They're going to swoop right in, offer them money, and they're going to get it. We're getting the Professional Anglers Association. It's a high-level pro tournament that's coming in October. And the main reason we got that is because they were able to adjust their asking fee down enough to where we could afford to pay for it. Otherwise, Paris Landing was waiting for us to say no, they were going to get it. That's the big issue, is the money. I mean, when we talked about the ramp before, it's like, well, we can get the elites and all that, and I'm like, That'd be great. If I had a $13.6 million tourism budget like Louisville, we would have every fishing tournament known to man.
I know they do like to fish out of here. And-
Oh, yeah,
And
and-
they like Ken Lake because of the way that they can move up and down the lake without, you know, with the dam, it's a good facility where they start, but they start at,
But they've got to go all
The one
way
end of the
down.
li-
And if
exactly,
they want to fish the
exactly.
Tennessee side, it's the longer trip.
exactly.
And it is. Ken Lake would be good. It's getting the Department of Fish and Wildlife and Department of Parks to work together to do it. Fish and Wildlife actually suggested there's a lot of area up at Ken Lake Marina right now where they could actually put parking in.
Well, we
But they would have
had
to
that
fill-
discussion about 3
Yeah.
years ago. and
They would have to fill all that in and then
Right.
take the earth.
If to basically take the top off of that hill and,
Yeah, which could be done because it's undeveloped. We have over 1,000 acres of undeveloped property there.
yeah,
Ken
so I
Lake, which
mean,
that's a whole other
there's
issue
other
we could
options.
get
The only reason that they keep
Yeah.
going back to that other location is the tennis center, and they might not want to use it in that way, but it just seems like it's something that would be an ideal place for these kind of events.
Well, this is just Randy talking, not the state talking. They need to use the tennis center for whatever they can use the tennis center for, because the
That's-
tennis center doesn't get a lot of use.
That's it, not, especially in the summer. Didn't get much in the winter, but it gets almost none in the summer.
Exactly. And, which I've told them, I've told them, I don't even know why they put the floors down in the summer. Just leave it as tennis. When it gets 100 degrees, the people from Murray will come down and rent the courts. Because that's mainly who rents the courts at Ken Lake.
Yeah,
You'll be very hard pressed to find any local people
Well,
utilizing those
I just
courts.
want to bring it up and put you on
And
the
I
spot.
agree with you. I just wish I had the money to
Understand.
afford those tournaments. In fact, we've got another tournament probably gonna wanna come in next May, and my budget is basically already tapped out for this fiscal year. And it's gonna be about a $15,000 tournament, and I'm gonna have to figure out a way to find the money to do it, because if we don't do it, guess where it's going?
I understand.
Paris.
Okay,
All right.
thanks.
Thank you, Randy. Next, we did advertise for a bid opening for the county website. In our paper of record, a bid opening has been scheduled for July 15th for the redevelopment and redesign of the county's website. Notice for bids will be published in today, as well as the July 15th edition of the Tribune Courier. We have, are these bids or that's just?
No, that's the,
Okay,
that's the specs.
all right.
Okay, so I'm sorry.
We have two bids. I don't know where our GIS fella is this morning. Is he in?
He's in the office doing that.
The first bid is from Cyber Websmith, Inc., 1207 Popular Street, Benton. Pleased to have the opportunity to place a bid on the Marshall County website redesign and redevelopment. Closed, you will find all the information for the current bid, to include a proposal summary, cost breakdowns. This is from Bill Culp, COLP President. Okay, the cost breakdown, construction and population of a new website, including mobile site, $5,737.50. Additional pages, $45 each. Labor beyond construction, $60 per hour, or $695 annually. There are no scheduled reoccurring monthly or yearly costs, but updates are done at our hourly rate of $60 an hour. We have no minimum charge, so if the update takes 2 minutes, it only costs $2. We have extensive experience with clients that need to make occasional updates after the construction is complete, and hourly maintenance is more cost-effective. However, if you desire an annual maintenance contract, we provide unlimited updates for $6.95 a year. The second bid this is from Paul Anthony Holt. He gives a little pedigree, proposed summary. I guess it's the cost breakdown, okay. Cost breakdown not to exceed $5,000, which is approximately $500 per department. Price for additional page, $25 an hour. Time base determined by detail and content. Host server, domain name, $80. Between $80 and $130 a month. Webmaster on call is a minimum of $100 a month. Did you say? Would you like to look these over and kind of give us your opinion? You are a computer guru, so we'll hold off on that until he can give us his opinion. It was brought up at our last meeting on some property near the county park. The people that own the property contacted they've contacted my office, but I haven't talked to them. But they did talk to the chairman of the refuse board and wanted to know if they built a tall fence around the property so it couldn't be viewed by the motoring public. Would that satisfy the court? Told them I didn't know, I would bring it before the court.
I think that's what the state reg is, isn't it? If you have a lot of junk vehicles, and I think this particular property does, I think they allow for a
think that's
fence to mitigate a proposed nuisance
That's
complaint.
what the gentleman on Castle Drive did, if you
Yeah.
remember.
Yeah, I don't remember how tall it has to be, but I do remember another property owner in 62 opted to do
I
that.
believe it's 14 feet, but I'm not sure. We'll check the regulation, but just wanted to make you aware that they have contacted and there's some movement going on, so I'll keep you abreast. Expanded jurisdiction, we had a meeting yesterday morning. Jeff, do you want to kind of tell them where we are on that?
We are working on a interlocal agreement, setting up the administration for the expanded jurisdiction in the county and the cities. And we should be, hopefully we will have that available in the next couple of weeks for your review. But that's kind of what we accomplished yesterday, is some basic proposals for this interlocal agreement.
Well, as I pointed out, and I had a doctor's appointment, and I was not able to sit in for the whole meeting, but I expressed to the representatives of the city of Benton and the city of Calvert that up to this point, fiscal court's been out the money. And I expect from this point on that we have if we're gonna be a partner, we're gonna have an equal partnership. and then we're gonna have to share the cost of this person. Because it started out, if you recall, we were told, well, we're gonna base that person over at City Hall. Well, that went down the tube quick. Now, we think we've got a better solution. We have an office open right here at the top of the steps, near the GIS office, where, you know, a lot of people do a lot of business, and it makes sense to have it here. But for the same token, when we do that, we're gonna have to hire a person to be in that office, and I expect that cost to be shared by all the entities that are using this service. Anyway, we'll keep you informed as we move along. This has been one of the most frustrating things, I believe, for Jeff and me and Marty and everybody involved. And it's because of a state mandate. I want you to know this is not something that we dreamed up, not something that we particularly wanted to get into. We've been in the electrical inspection business for some time. But with the passage of the Larry Clark bill, it became state law that now you must have not only an electrical inspection, the state provides the plumbing inspection, now you have to have a structural inspection. So, as you can imagine, the fees are going to mount up. This not only applies to new dwellings. If you're gonna add on your house, or you're going to change the footprint of your house, you're gonna have to get a permit to do that, countywide. And, you know, the bottom side of that, we could just say, well, we're not gonna mess with it. Fine and good. State said that's okay, we'll come in and take it over. But you wanna build a house or you wanna add on, it might be a month, 2 months before we can get to you to take a look at what you're wanting to do. So we're kinda in a spot here. We don't want our people having to wait that length of time if they're trying to build new property or make additions to their property in this county. So bear with us, we'll get it all worked out, but we've been working on this now, what, 2 years? About 2 years. So, next is our bid opening for our bank deposits. Is Tim here? All right. We ran in our paper a record. They were hand delivered to our financial institutions to give people the opportunity to bid on our bank deposits. We have 2 bids. And I've asked Emily to get our county clerk, who's also our former county treasurer, to come up to give a good analysis of the bids. I think we have representatives of CFSB and our current Heritage Bank is represented here today. You didn't let John out of Hopkinsville? We appreciate y'all being here and bearing with us this morning. This first bid is from Heritage Bank. In accordance with the term of the general conditions specification, all accounts of the Marshall County Fiscal Court shall be serviced without charge. The bank agrees that no minimum balance shall be required at any time, and the bank shall factor any and all expenses of servicing the court's account into the interest rate shown below. Interest shall be paid on all deposits maintained by the Marshall County Fiscal Court starting on the date of deposit. Interest shall be calculated compared to the federal fund daily rate. The plus or minus basis points stated below will be paid on the daily balance, and a floor rate is required. Interest shall compound daily. The plus side on it's 0.12 basis points. Am I correct? 0.12 basis points. The floor is 0.82%, below which interest rate will not fall. And they have all of their backup information and everything I think they've got here. Our next quote is from Community Financial Services Bank, Benton, Kentucky. Thank you for the opportunity to bid on the banking service from Washington County Fiscal Court. Enclosed, you will find the official quote form. CFSB can meet and exceed your financial banking needs and provide all the quoted terms stated in the general conditions and specification request. We value what your organization does for our community, and we would appreciate the opportunity to build a relationship as your financial provider. In accordance with the terms and conditions and specifications, all accounts of the Marshall County Fiscal Court shall be served without charge. The bank agrees that no minimum balance shall be required at any time, and the bank shall factor any and all expenses of servicing the court's accounts into the interest rate shown below. Interest shall be paid on all deposits maintained by the Marshall County Fiscal Court starting on the date of deposit. Interest shall be calculated compared to the federal fund daily rate. The plus or minus the basis points stated below will be paid on the daily balance, and a floor rate is required. Interest shall be compounded daily. The plus 0.26 basis points, 0.26. The floor 0.61%, below which interest rate will not fall. I'm going to ask our finance officer, our county treasurer, and our county clerk to review this, make sure everything's in order, and make a recommendation to the court. While we're doing that, and I don't think I put this on the agenda, Mr. Edwards, it was, I believe, requested that there be a addendum or to the nuisance ordinance. Jeff, I think you want to go over what changes you made so we can get the approval.
On the second page, number 7, the language that I have put in is that notice shall also be sent to the last registered and legal owner of the record of any items located on the property where registration and documentation of legal ownership are applicable, unless the owner is the owner or occupant of the premises wherein the nuisance is located, unless identification numbers are not available to determine the ownership of the vehicle or the property is of which that there is no documentation of ownership. The notice to abate and the right to request a hearing shall also be posted on the property itself in a conspicuous location fastened to the property in a secure manner without damaging the property no less than 10 days before action is to be taken, and the Marshall County Sheriff shall make an affidavit attesting to such facts where the property that carries a registered title registration of ownership is found upon any public property within the county. Notice to the owner is that all that shall be required. Where property that carries no evidence of ownership is found on public property, no notice shall be required. That contains the information as requested regarding posting the notice on the property. That's it.
Explain that in layman's terms.
At 10 days before action is taken, you have to post a notice on the property.
10 days for what action's taken?
I would post it I mean, when you decide to send the notices out, I'd post it. That way it takes care of it.
So in addition to,
Well, I mean, is it not clear? I mean, I think that's,
Okay.
so it's in addition to Kev's letter,
yeah.
you post a notice.
Which is ridiculous in my opinion.
Well, Kevin, I was asked by the court
I
to
know
prepare
that, but
that.
I understand that, but I mean,
And I was just trying to find a way that we could make sure that people aren't saying they don't know. I think the whole thing needs to be redone. I've told you that. I think that you all are taking on a burden, and I think the refuse department, now we've got Troy, who's doing a lot of work on it.
It's redundant, in my opinion, to send a registered letter, then me personally go to that property and post something. Let's forget the letter and just go post it and be
Could
done
we
with
do
it.
that? Or
I
do you
don't
have to
think
send
we
registered
can.
letters?
I would agree with you, Kev, but I don't know that legally we can do that. I think we legally have to give them a registered letter. Isn't that the law?
So
I
if you've
think
got a
that-
bad address, then
Right, I know,
yeah.
Well, it's not only that.
How can it be a
Kevin's
bad
sending-
address? Because I'm the one researching it and I'm the one putting the addresses out there. I should be the one to know if the address is good or bad or not.
I guess
I'm
whether or
going
not it's
on the
updated.
tax record that's in my office of where the tax bill goes to. If that's not good enough, then I'm sorry. And like I said, I'm sorry I'm upset about this, but me, that's ridiculous to send a registered letter out and then go post it on the property itself. To make sure somebody gets notice.
There
I
shouldn't be
mean,
any bad addresses.
that's what I'm saying. That's my
And I wouldn't think so,
argument
other than
completely.
we've got a family that's saying, hey, we didn't know our house was gonna be leveled, so that's why this suggestion was made, and I agree, it's too much on you already.
And that family
I just-
was notified 3 times over the last 6 years.
And one of them came to my office and showed me where she had gotten the notice and admitted that she knew about it. So the fact that they're claiming that they didn't have notice, I think kind of rings hollow.
If that's what y'all agree on, I'll do it. I'll do whatever the court says to do, but I'm just telling you now, it's ridiculous in my opinion, but I'll do it.
Well, if you don't think it's gonna happen again, if you all don't think we're gonna have situations where people are going to say, we didn't know, or our house has been leveled, and, you know, if there's not gonna be a potential liability, then I just threw that
That
out as a
can't be a
suggestion.
liability. Like I said, he already said that they've done admitted, and like I said, I got documentation 3 times that we sent notices to them.
You know as well as I do how this is. When you start taking people's property down, there's always, I didn't know. I just want to make sure that we're doing everything on our end to cover any
Well,
liability we
you know,
might have.
Don't we have the
I think Kevin has told
situation,
me before, and correct me if I'm wrong, Kev, he sends these registered letters. Now, if they come back to him undeliverable, we've done everything in our
That's exactly
power
right.
to try to get to these people. I don't know.
don't we have the situation, though, we've had this tax issue before, and I know so my family's been involved, where somebody owned the property in December, and then they sold it, but the tax bill doesn't get changed for a year, and the tax bill goes back to the person that owned it on January 1, but then they sell it and they don't get the notice the
That's
next
the way-
year.
And that's not the responsibility of us in any way, because.
Oh, I
and it's-
understand
and it's
that
been
as far
told
as the
time and time
tax.
again.
But that's the way that you would end up with an
But
address
when the
that wasn't
property's
correct.
sold, they know it up here. And
Yeah.
like I said, you know, you think I'm smart enough to come up here and find out who the owner is through Tony's office?
Well, that's
Now,
good
that's-
enough for me.
that's
if
where
the
I'm at
case.
with it, guys.
Yeah, that's the only thing that I run into. I know like I said, some of our family, they didn't get the notice and they didn't go back and check. They bought a place, and then all of a sudden this tax outfit out of Texas gave them a big bill
Yeah.
3 or 4 years later. That's
Yeah,
the
and
only
it's
situation.
not an insult to you in any way. The problem is that not all the addresses are right. No matter how much you research it, and I've told you before, I don't think you should be doing all this in the first place. I don't want to burden you further, but I also don't want us to get into a situation where a property owner legitimately didn't know, or they've had a death in the family, or they've had a change of address, and you have some of those circumstances. So it was just a suggestion, and if you all don't want to do it, then I hate that Jeff went through the trouble of having to redraft an ordinance it was only a suggestion to see what further measures we could take to make sure that we don't have this problem or potential liability.
We don't go through this with the court system, Jeff. If it's a bad address, you don't get no reprieve on that, and you know that.
I understand, but the
But
court
then on the
systems
other hand,
aren't
most
leveling properties like we are.
condemnation
I mean,
ordinances have a posted notice too.
Whatever, if y'all wanna do it, I'll do it. Like I said, I just letting you know where I
Jeff,
stand. I'll do it.
are you gonna have something in general that he would post? Or, I mean, it'll just be a form letter, won't it?
Yeah, that's what it would be.
Well, if I were him and I was gonna post it,
Why
I'd
not?
post it the day I go out there. The first time I looked at it, I'd just post it right then. I wouldn't make a special trip to post it, because like, we got too many hoops to jump through now with this.
You know, I had special citation books made, and I showed them to you, did I not? And you said that would suffice for their notification.
I'm not saying you're doing anything wrong.
No, but what I'm saying is, why do another form? I'm just like him. Why don't we just take that and post it on the
Okay.
door?
I'll do it however you want. It don't matter to me.
yeah, I made the suggestion, and it was only because I thought, okay, if people are going to say that we didn't know, or the neighbors are gonna say we didn't know, we could have made contact while we're there, could we post something? I mean, and you find that with condemned properties and such, I don't want you making another trip, I don't want you spending the gas, you know how I feel about that. So if it's something that you can do while you're there, great, and if not, I'll withdraw the motion
I'll post
to post anything. I'm just trying to keep us to where we don't have a potential issue with somebody saying they didn't know.
I'll do it. Like I said, if y'all agree to it, I'll do it. I won't question it.
Well, the
I
county
don't
attorney was
think, I don't
actually,
think Kevin hurt to post it but I would do it the first time I go. I wouldn't make a special trip. If someone forgot or it was gone, I wouldn't go back. But you could post it the day you go look at the property to determine if you think it needs a letter sent. I'd post it right then one time. If that was 6 months prior, I wouldn't care. I'd just post it right then.
all right, any other discussion on the amendment to the ordinance?
That would be the first reading.
This will be the first reading of
And if y'all don't think it's needed, then.
2014-07. Do I hear a motion to pass the revision of the notice? Or the first reading?
You're sure you're okay with that? Because I don't care to withdraw the motion.
I'm good.
Make a motion to approve, Judge.
I have a motion, is there a second?
Second.
Motion and second, all in favor of the motion say aye.
Aye.
Any opposed, no. Motion carries, we'll have the second reading at the next regular meeting of the court. Have you had an opportunity to review the bids on the bank deposits?
Tim is currently working.
Looking
up-
on it now. Okay, let's move on. Any other old business, by the way? I'm sorry.
Is Andy ready? You think, Judge?
Andy, have you,
I have, I'm gonna need to get in touch with them, and get some clarification on some stuff.
all right, so we'll take action at the next meeting. We'll give you until that time. Okay. That'd be okay with
Yeah,
everyone?
that's fine.
Tim, do you have a recommendation?
Well, I don't know that I've got a recommendation, but I can tell you what we've got. Right now, the Fed fund rate is 0.25. The Fed fund rate would have to be 0.56 for both of these rates to be equal. If it's less than 0.56, which it currently is right now, Heritage has a better rate. If it's more than 0.56, then CFSB has a better rate. So what y'all need to determine is what you expect to happen with the Fed fund rate. And Jennifer told me that the Fed fund rate has been 0.25 since 2008, correct?
Yes.
Which I think when we did this 4 years ago, I probably told you that I thought there was no way the Fed fund rate would stay 0.25 for as long as it has, because I thought inflation would kick back up, but it hasn't. And I don't have a clue what will happen in the future. So that's the decision. That's why y'all get paid the big bucks to make this decision. But does anybody need me to repeat these numbers?
What,
0.56 is the magic Fed fund rate number. Right now it's at 0.25. So it would have to more than double but I mean, there were times where the Fed fund rate was 5%, I guess, you know, I mean, who knows, you know?
2005, it was 5.05.
So at that point, the CFSB's rate will be .14. Anytime the Fed fund rate goes above .56, CFSB's rate will be .14 better than the Heritage rate. Isn't that right? All these points and everything. So that's where you stand. It's kind of a decision of what you expect the future to make, but,
I wish we could.
yeah.
What about the bottom? There was two numbers.
That's it, the two floors.
That's the two floors,
That's what we're
yeah.
talking about here,
Yeah.
is because Heritage's floor is a higher rate than CFSB's floor, that the fact that the Fed fund rate is low right now means their rate is better right now.
Okay,
All right,
what's your pleasure?
So Heritage has the highest bid today. Make a motion to accept Heritage bid then.
This is what you look at it. I don't know if it could change tomorrow, Terry.
I meant, but today, as we
Yeah,
speak,
yeah.
Heritage has the highest bid. Make a motion to accept the highest bid.
You heard the motion. Is there a second?
Second.
Motion and second. Any discussion? Hearing none, all in favor of the motion, say aye.
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 Any opposed, no. Motion carries. All right, let's move into any other old business. Let's move into new business. We have, from the Finance and Administration Cabinet, under House Bill 388 and House Bill 337, effective July 1, 1998, KRS 31185 was amended to read as follows. The fiscal court of all counties or legislative body of an urban county government shall annually appropriate 12.5 cents per capita of the population of the county to a special account to be administered by the Finance and Administration Cabinet to pay court orders entered against counties for the defense of the indigent. Adhering to the 2000 decennial census figures, Marshall County's contribution is $3,766. As we begin the 2015 fiscal year, these funds are due and payable on or before September the 15th, 2014. J.W. Bryan, County Fees Branch, Frankfort, Kentucky. Do I hear a motion to pay our bill for the defense of the indigent in Marshall County?
Make a motion.
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. We have the county clerk's claim for motor vehicle and boat bills for 2014. As required by KRS 133240, Section 3. The Department of Revenue hereby certifies that the total number of motor vehicles and boat accounts for this county is 41,454 as of January 1, 2014, for which the fiscal court shall pay the county clerk 15 cents for the calculation of a tax bill for each account. Total number of bills as certified above times 15. Total amount to be paid by the fiscal court, $6,218.10. Is that correct, what we paid?
Yes.
All right, you've heard the request. What's your pleasure?
Motion to approve payment, Judge.
Second.
I have a motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. We have an opening on of our Board of Assessment Appeals. I would recommend Kip Mathis. Kip is a local attorney, does deed recordings and tax work. I asked if he would serve, and he said he would be willing to serve on our Board of Tax Appeals. What's your pleasure?
Motion to approve the appointment, Judge.
Have a motion, is there a second?
Second.
Motion and second, all in favor of the motion, say aye. Any opposed, no. Motion carries. Treasurer's report, Emily?
For the month ending June 30th, 2014, general fund had a book balance of $331,772.23. Road fund, $174,829.98. Jail fund, $150,359.36.
Wait a minute, whoa, hold on, let me catch up. You're on the jail fund now?
Yes,
Okay.
sir.
185,987 on that?
No, it'll be this one.
Okay, 150,
Yeah.
359, okay.
Grant fund, 652687. 911 fund, $138,800. Occupational tax administrator, $3,258,839.30. And the veterans band fund, $2,631.26, for a total of all reportable funds is $4,063,759.
Any questions on the treasurer's report? Now, to make a motion, we approve the treasurer's report subject to audit.
Motion to approve the report.
Have a motion, is there a second?
Second.
Motion and second, all in favor say aye.
Aye.
Any opposed, no. Motion carries. Accounts receivable report,
As of June 30th, 2014, the sheriff's office owed $576,425.56. The county attorney's office, $15,159.23, and the clerk's office, $30,661.10, for a total of $591,584.79. Since that time, the county attorney's balance has been paid, the clerk's balance has been paid, and the sheriff's office paid a little over $100,000. I don't remember right off the top of my head, but a little over $100,000 on that balance as well.
any more questions of Emily? I entertain a motion to approve the accounts receivable report.
No,
approved.
Second.
Motion and second, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. County treasurer's settlement,
My treasurer's settlement, the general fund had a total revenue of $8,017,779. Road fund had a total revenue of $4,205,335. Jail fund, $2,046,266. Grant fund, $34,340. 911 fund, $646,753. Occupational tax administrator, $3,367,799. Veterans band fund, $8,167, for a total revenues for the entire fiscal year of 2014, $18,326,439. And then it goes through and recaps every fund. General fund, and I can read those again, but it's gonna reflects the same amounts as what are on the treasurer's statement.
any questions for Emily? If not, I would entertain a motion to accept the treasurer's settlement subject to audit.
Make a motion.
A motion, is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Is this the same thing?
No, that is our quarterly report.
Okay.
It does reflect many of the same numbers, but it needs approved, and
Yeah.
it was not on, it's not on there in the encumbrance report. You want me to go ahead with those?
Yeah, go ahead.
Okay. Our encumbrance report, which is this one here, Judge, the general fund had a total encumbered balance of $13,115.92 for the quarter ending June 30th. Road fund, $23,315.07. And jail fund, $4,140.97 for a total of $40,571.96.
All right, do I hear a motion to approve the encumbrance report?
Motion approved.
Have a motion, is there a second?
Second?
Motion and second, all in favor of the motion, say aye.
Yeah.
Any opposed, no. Motion carries. Go ahead.
Our quarterly report, it reflects also the same numbers as the treasurer's report, treasurer settlement, and it also includes the encumbrance numbers. Total of all reportable funds, again, we had a ending cash balance of $4,063,759 after encumbrances. And there's documents attached to support all that, this is the report that we send to DLG for our, fourth quarter final.
You need approval.
Yes.
Motion approved, Judge.
Have a motion, is there a second?
Second.
Motion and second, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. Interfund transfer.
Interfund transfer report, I'm asking your approval to move from occupational tax administrator to general fund, $750,000, occupational tax administrator to road fund, $100,000, and occupational tax administrator to the 911 fund, which is our budgeted quarterly subsidy of $31,250,000, for a total of $881,250 out of the occupational tax administrator fund.
Motion approved.
Have a motion, is there a second?
Second.
Motion and second, any discussion? Hearing none, all in favor of the motion, say aye.
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 Any opposed, no. Motion carries. Anything else, Emily?
No, sir.
All right, our animal shelter report as of June 31, or for June. Animals in the pen as of 5/31/14, 58. Animals brought in by wardens, 44. Animals brought in by citizens, 87. Total animals taken in, 131. 39 dogs, 14 cats, 37 puppies, 41 kittens. Animals adopted, 80. 0 animals in foster care. Animals reclaimed, 14. Animals euthanized, 16. Animals in the pen as of 6/30/2014, 79. Looks like we're going backwards. A month before, we had 58 in the pen and 79. Adoption fees of $2,677. That's your animal shelter report for June 2014. We have from the Bryansburg Fire Protection District their budget for the fiscal year 2014-2015. Their projected revenue is $268,000. Projected state aid is $8,250. Projected non-revenue $500. Projected bank interest $1,100 for a total estimated revenue of $277,850. They're expecting their expenditures to be pretty much the same, $277,850. Training and travel, operating expense, insurance, utilities, maintenance on the building and grounds, annual reimbursement. So they also have a projected ending balance for 2014-2015 to be $301,500. That's your projected budget for the Bryansburg Used to be Bryansburg Palma, did it not?
It's Palma Bryansburg now.
That's what I'm thinking. It just says Bryansburg, but it's Palma Bryansburg Fire District. Do I hear a motion to accept their budget?
Make a motion, Judge.
I have a motion. Is there a second?
Second.
Motion and second. All in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. We need to hang on a little. From the Aurora Ross Fire Protection District, we have their annual audit as of June 30th, 2013. It is available for your review. There was one recommendation from the auditor, Kim Ham. The district did not prepare a management's discussion and analysis. We recommend that the Board of Trustees review sample MD&A from other similar districts and appoint one person to prepare the MD&A in order to comply with this part of GASB 34 in the future. It has all of their management responses and the findings from Kim. It's there for your review. I would entertain a motion to accept the audit
Make a
of the
motion.
Aurora Ross Fire Protection District.
Make a motion, Judge.
I have a motion.
Second.
Motion and second. Any discussion on the motion? Hearing none, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries. One item before we, I don't know, did you get a copy of the thing?
The hours for Troy?
Yeah. Troy brought in a list of hours that he has spent on these cleanup things, just as the sheriff has spent many hours, so the refuse department. We are making progress. I don't know if you've seen some of the pictures of the properties that are being worked on as we speak. Jeff and I talked about it briefly. We did say that we would consider reimbursing the refuse department. I think it would have to be the refuse department, not Troy individually, is that correct?
Yeah.
And then they can make whatever arrangements they want to make. I don't know what would be fair, and nobody has given me any number on that, but I do think he's going out at night and doing work after hours, and
We would need to pay, we would need to reimburse them in order to put that into the lien document. Wouldn't that be correct?
Whatever you spend.
Kevin, how much are you spending? I think he needs the same treatment. His office should receive the same treatment as refuse. I know it's costing his department a lot too.
Yeah, just whichever properties it is, and I've got logged.
depends on how many trips you have to make, things like that, Kev. I mean, I'm not saying that.
That's fine, that's.
You know, but I just think we need to come up with an amount.
Yeah, we've got to do that in order to look like to me to capture it into this lien.
Well,
that we're gonna play
you
our-
can do it either way. Your lien can be, what you're saying is, do we pay them and then collect it, or do we collect it and then pay them?
Okay, well, it'd be.
Either
one-
way it'd work.
Whatever.
You've got a bill from the refuse district, you can either pay it and then that be the lien, or you can use that amount and put that in the lien anyway.
Okay.
For us, Jeff, it wouldn't work that way. Because once we close our books, none of that money's can be put back in on that year's.
I know, but from their standpoint, it doesn't matter. From yours, it does. I mean,
Yeah.
yeah. I see what you're saying, and that's not what I meant. You would need yours up front.
Yeah.
Yeah, once you close your books, you can't,
Nope.
yeah, I understand. You don't wanna give that some,
Be receipted into the current.
you don't wanna give that some thought, Kev, if you and I can sit down and try to figure something out that's equitable and fair, that I can bring back to the court.
I think that'd be good.
All right, is there any other business? Josh?
Judge, I failed to get the signature on this application for the work record certification. I need to get your signature on that before I forget. I'm sorry about that. Yeah.
Right here?
It was paperclip to the back of the picture.
Oh,
I just found it.
I don't understand.
Let's, I think that's on time deal.
Any other business or anybody else to address the court?
Judge, I had a couple of things that came out of our meetings last week, at Louisville.
Yep.
Larry, do we have anything, have you got any kind of a application in for the recreational trails, grant program with DLG?
We're waiting on a property acquisition to get in the grant.
Well, they're short on applications this time, and they actually have closed that grant application time, and now they're about to reopen it. And according to what I understand, this is walking trails, could be like walking trails at the park to resurface, or something like that. I don't know if you wanted to check on it.
Some of our trails do need resurfacing.
Well, they've got 19 applications, and they've really got more money than that right now. This is an unusual situation.
If I understood Tony, we can go ahead and apply.
It may be. He said, he said in the meeting that they were gonna reopen, so it might be worth looking at.
I did get some quotes on resurfacing the trails. It's a matching grant. You're looking at about $120,000 to resurface, so you're talking about $60,000 to come up with, so that was more concerned. I need to talk to the board on how much they would want to apply for.
Well, now, I thought this recreational trails right here was 100%.
The ones that I saw,
I did check on it. I thought this recreational trails, I thought he said was 100%.
I'll check on that.
I don't know, I may be wrong, but I thought that's what Tony said in that meeting we had.
Round table, yeah.
The only other thing, I know the Commissioners Magistrates Association, their big push for this coming legislative session's going to be, one of them's gonna be 911 cell phone, or some kind of fees to cover that. They think they'll have a better chance in 15 than they have ever had, and then lift the program about the sales tax that the community can vote in if they want to do a project. Those are the two items they said they'd be looking at.
Our executive board and the full membership meeting, pretty much the same thing, Bob, as Magistrates Commissioners, that we're gonna make another push. And I just made the comment, you know, fellas, we've been dealing with this for years. What makes you think that we're gonna have a better chance next year? Well, you know, it's election year. I said, everybody's running sometime, you know, but that is a priority of ours as well. The LIFT program, and I had met privately with Mayor Fiscal after he made his presentation, and then I went to the roundtable. The LIFT program is a program the legislature did not pass on it this year. It got close, but what it does, if a county or city has a project, let's use, for example, our children's art theater, and we place the question on the ballot, do you want to impose a sales tax of whatever percent,
1 cent.
1 cent, to fund this particular project? And the people vote yes or no. Then you sunset it. You show what it's gonna cost to do this project. Once that's done, it sunsets and goes off. Every step of the way, the people of the community have the vote. They have the say whether or not the project meets their approval. I mean, this could be with Parks and Recreation, this could be with
Well, it could be
About
what
anything.
Josh mentioned about
But economic
industrial.
development, you could use that as a tool to build a industrial park to entice industry. But all along the way, first of all, the fiscal court has to approve to put it on the ballot. Then it goes on the ballot specific to what you're wanting to do. And then if the people say yes, you have the time frame that it will stay on and then expire. If they say no, that's it. Doesn't happen. I mean, it appears to me that's the democratic way. You're not imposing anything other than a suggestion to the people, but they're gonna bring that up again. That's gonna be another push. Now, the Kentuckians for Better Transportation, Lady Bob, I don't know if you were in there when she was talking, something about the floor that the legislature did not pass this time on the gas tax.
On the gas tax. Yep.
And her assessment was it was gonna cost the state between $24 and $30 million a quarter. That's a lot of money out of the road fund.
Well, they've already actually stopped one project on I-65
Yes.
because they're not sure if they'll be able to fund it.
Well, this money is used to match the feds.
Yep.
And if they don't have the money to match it, now in talking to Commissioner Pasley, our rural road fund is still in fair shape, decent shape.
Yeah.
So we have to watch this very closely because, we've got I-24 and now I-69 coming. I would like for the fiscal court to consider something. I'm just putting this out for your consideration. The people of the county, my phone, emails, letters, have been overwhelmingly against closing the Purchase Parkway from the interchange of I-24 to Calvert City. That's a main artery for a lot of our people in the south end of the county, from the Benton area, and other workers at our Calvert City Industrial Complex going to Calvert. When they came and talked to me, it was just a matter of fact, this is what we're gonna do. I believe after that hearing in Calvert City, when over 300 people showed up opposing it, we're hoping they'll go back to the drawing board. But I would like the fiscal court to consider, and if Jeff, you'd work with me, nothing elaborate, but a short resolution objecting to that closure. But because I think it'll be detrimental to our citizens, it'll be detrimental to the workforce at Calvert City. It could cause a bottleneck if people start using the old route on 95, where you've got a North Marshall Middle School and people going to Calvert Elementary and people trying to get into the plants at the same time. It could cause some real bottlenecks.
And the truck traffic.
And the truck traffic.
Gonna
Your
redirect
emergency
all the
response
truck
times will go up
Absolutely.
because of
Absolutely.
that.
I think
Sure.
they said 2.5 minutes is what they were
Exactly.
estimating.
Yeah. So I'd like y'all to consider that, and
I'd make a motion that we do it. I don't know that we need, do you want to have something maybe ready to present at the next meeting,
well, I
Judge?
started to say if we could get something
Yeah, I'll get
ready,
you a
just,
resolution.
and it doesn't have to be elaborate, just a
Sure.
resolution saying that we ask their reconsideration, that we feel it would be a detriment to the traveling public, particularly to the citizens of Marshall County. All right, you've had an opportunity to review the bills. Do I hear a motion to pay the bill?
Motion to pay the bills,
Have a
Judge.
motion, is there a second?
Second.
Motion and second, all in favor of the motion, say aye.
Aye.
Any opposed, no. Motion carries.
The Kentuckians for Better Transportation, the lady Juve Barber, they're gonna be, and she's gonna be in Paducah at the Siemens Church down there Thursday. I'm not sure what time. She was supposed to send me an email, but she didn't, and just to talk about transportation in this area. Okay. Okay.
Okay. Make sure all the court members know the time.
That'd be good, thank you.
All right. Any other business? Oh, yeah. Let's recess. We have a public hearing scheduled. I think it's scheduled at 11 o'clock, and we're a little past that. I'll entertain a motion to recess the meeting.
Make motion, Judge.
Second.
A motion and a second. We in recess. All in favor say aye. Motion carries. We'll consider ourselves in a public hearing. The purpose of the public hearing, Marshall County Fiscal Court will hold a public hearing at approximately 11 o'clock on Tuesday, July 15th, in the Joe Williams Courtroom, Marshall County Courthouse, 1101 Main, Benton, Kentucky. The purpose of the hearing is to receive comments either for or against the county accepting the following roads into the Marshall County Maintenance System. Quail Hills Road, located at 2.68 miles north of the intersection of Tatumville Highway on Little Bear Highway. Sparrow Lane, located off Quail Hills Road, Quail Hills Subdivision. Pheasant Lane, located off Quail Hills Road and Quail Hills Subdivision. Anyone unable to attend may submit written comments prior to the hearing to Mike Miller, County Judge Executive, Marshall County Courthouse, 1101 Main, Benton, Kentucky. We appointed our road viewers, Russell York, Josh Tubbs, Bobby Gifford, and Casey Counts to review the road. Do you have a report? Okay, here we go. Is your report this lengthy, guys?
Petition is attached, Judge.
Pardon?
The petition is attached.
Oh, okay. I thought you were gonna make me read all this, Casey. At the July 1, 2014 session of the Marshall County Fiscal Court, a request was submitted for county road maintenance for the roads in Quail Hills subdivision. Advertisement for public hearing was placed in the July 8, 2014 issue of the Tribune Courier. Notice for the hearing was also posted in the following locations: the courthouse, the intersection of Quail Hills Road and Sparrow Lane, Quail Hill Roads and Pheasant Lane, and 200 feet from the intersection of Little Bear Highway and Quail Hills Road. County Engineer, County Road Engineer Russell York, County Planner Josh Tubbs, and appointed road viewers Bob Gifford and Casey Counts all viewed the road. During the on-site inspection between July 9, 2014 and July 14, 2014, the following observations were made. Quail Hills Road is located on Little Bear Highway, 2.68 miles from the intersection of Tatumsville Highway in Gilbertsville. This roadway is 932 feet in length from the center line of Little Bear Highway to the approximate location of the TVA USA boundary at the 375 contour on Kentucky Lake, and has a roadway width ranging from 15 feet to 9 feet. Sparrow Lane intersects Quail Hills Road 206 feet along the center line from the intersection of Little Bear Highway. Sparrow Lane then runs a total distance of 765 feet and has a roadway width of 12 to 13 feet. Pheasant Lane intersects Quail Hill Road 470 feet along the center line from Little Bear Highway. Pheasant Lane then runs a total distance of 560 feet with a roadway width ranging from 10 to 12 feet. All roadways have an asphalt surface that is in poor to moderate condition with numerous holes, cracks, and upheavals created by tree roots. Ditching is present at some locations, primarily on the downward grade of Quail Hills Road. One concern would be the extreme erosion of the roadbed on Pheasant Lane. Examination of the plat by the petitioners and and located in the Marshall County Clerk's office on slide 321 reveal the following information. The subdivision was recorded in the clerk's office on January 5th, 1976. It should be noted that the resolution establishing requirements for subdivision roads was accepted April 1, 1975. None of those requirements appear to have been met by the developers of Quail Hill subdivision in the construction. Quail Hills, originally called Lakeshore Drive, has a total right-of-way width of 30 feet, which falls short of the 1975 requirement of 60 feet and the 2006 requirement of 40 feet. Sparrow Lane, originally named Oak Drive, and Hickory Drive, has a 30-foot right-of-way. Pheasant Lane, originally named Quail Circle, has a varied right-of-way ranging from 38 feet where it meets Quail Hill Road, then tapering back to a 30-foot right-of-way when in the turn. Both Sparrow Lane and Pheasant Lane have a turnaround drawn in the plat. However, a turnaround or cul-de-sac was never constructed. Sparrow Lane and Pheasant Lane would both be classified as dead-end roads. With the existing narrow roadways, turning around at the dead ends must be done in private driveways. The presence of parked vehicles and boats add to the difficulty in turning around. Quail Hills does have a turnaround located at the end. However, it is located on TVA USA property and not included in this petition for county maintenance acceptance. The turnaround has a narrow roadway width with curves that have inadequate turning radius of about 20 feet. This would not allow vehicles such as school buses, emergency vehicles, or maintenance equipment to turn around without those vehicles driving off the existing roadway. Based on the information and observations made during the inspection, we make the following recommendation. Quail Hills Road, Sparrow Lane, and Pheasant Lane are not eligible to be taken into the county road maintenance system due to the failure to meet the requirements listed below. Inadequate right-of-way along all roads as recorded on the plat, a minimum of 40 feet is required. Quail Hills Road, Sparrow Lane, and Pheasant Lane do not meet this requirement. 2, a cul-de-sac or turnaround must be located at the end of the road. Sparrow Lane and Pheasant Lane do not meet this requirement. Quail Hills does have a turnaround, but it cannot be taken into the county due to its location on TVA property. This is submitted by Russell York, Josh Tubbs, Casey Counts, and Bob Gifford. Do each of you have a copy of this?
I do.
All right. All right, at this time, we would open the floor. Is there anyone here to speak in favor of the county assuming maintenance of Quail Hills Road, Sparrow Lane, and Pheasant Lane? Anyone here to speak in favor of the county assuming responsibility for maintenance on Quail Hills Road, Sparrow Lane, and Pheasant Lane?
Yes.
Yes, ma'am.
I am. I'm Jean Jennings of Quail Hill Subdivision. My name is Chuck Windhorst.
Gene, you want to come around to the microphone? That way we get your name in the record.
Okay.
Thank you.
Is this all right?
Yes, ma'am. Right there.
Okay, I'm Jean Jennings. I live in the Quail Hill Subdivision. My neighbor, Chuck Windhorst.
Hi, Chuck.
We were the only two who were able to come today. But we are here to speak in favor of the county taking over the roads in our subdivision. And I just hope there's some way we can work this out. I mean, after hearing this recommendation, we have approximately 24 out of 28 lot owners who are in favor and signed the petition.
Yes, we do have a
So-
copy of the petition. Let me ask you, and apparently, and I don't know who developed this subdivision.
Bushart, I don't know his first name.
Was it Bussart?
Bushart.
Okay, but they developed it, or at least they recorded it in 1970 requirements. It was in 1976, and our road ordinance, the first one, went into effect in 1975. I'm curious as to why, you know, in order to take a road, we have to have proper right-of-way where we can properly maintain, ditch, and that vehicles can meet safely. To do anything other than that would be, well, it would be dangerous. Because if we accept the responsibility, we accept the liability that comes along with it. So my recommendation would be to talk to your neighbors that live in that area to see if they would be willing to give additional right-of-way. I mean, there is criteria that has to be met. One of which, and it was back in that time, 60 feet right-of-way, 30 feet from the center of the road. Reason we did that, the state required that back then. They've since backed off, and so have we. We now require 40-foot right-of-way and a 20-foot driving surface, 18 to 20-foot driving surface. Now, does every road in the county meet that criteria? Probably not, because a lot of the roads that were grandfathered in many years ago, that were built back in the 30s, and even further back than that, you know, the only description we have is fence row to fence row. Fence row's not there anymore, or tree line to tree line, you know. So when we got into this, we wanted to make sure that we would have the safety issue would be first. And that's the first thing that jumped out on me, because you've got some narrow roads, and Russell, you couldn't maintain those roads, could you?
It'd be kind of hard.
Now, I'm not speaking for the court, because they may say, well, you know, okay, but I'm just saying that jumped out at me. Do you feel like, or do the neighbors have enough that they could give additional right-of-way?
One problem.
It would create a problem because homes were located based on our 30-foot plat book, and it does call for like a 5-foot right-of-way from the from the gutter, you know, the property line. And I know my house is built at an angle, so you'd have a lake view, and it's only 5 foot from that 30-foot line. So if you had to make it 40, a few of us would be in trouble.
Yeah.
Their homes, and there is another home who, with 40-foot right-of-way, part of her house would be on your right-of-way, just like Chuck's.
Now, Judge, I know for a fact, the farm where I grew up off of Tubbs Road, I married in 75, and sometime after 1980, the county took that over. There's no 60-foot right-of-way, there's no 40-foot right-of-way, and there's one lane, chipped and seal road, to the back of that farm where my brother lives today. Now, that was in the 80s. We blacktop Walton's Lane, which is a one-way road. So that is, I don't know what the exceptions are. Maybe we need to add to our ordinance unless otherwise designated, like we did our policy for other things. But I know the exceptions can be made. And there's no reason for us to have a 40-foot right-of-way on those dead-end roads. And the condition of the road now shouldn't matter, because we are accepting, if we accept the road, we're accepting, they're paying half and the county's paying half, just like we have everyone else. All the roads we take in are not in top shape, so that doesn't matter either. So, but the fact that that road, it wasn't taken in and considered a 60-foot right-of-way in 1976, that doesn't add up, because there's many, many others. I don't know what the exceptions were then, but they were made. And I'm for making one here.
That's your call. Everybody can vote the way they want to. I'm just saying, when we put the ordinance in effect, they had to grandfather a lot of roads in that were there in existence at that time.
Exactly.
We
But
put the ordinance-
they've added them since, Judge, without following this policy.
Well, that may be, Terry. I'm
It's
not
not
gonna
a
argue
may,
the
it's a
point
fact.
with you.
It's a fact.
I'm just saying, you're taking on a liability along with responsibility.
I'm just saying that has happened before, and if we can, a 30-foot right-of-way doesn't make the road any more narrow. If we can consider an 18-foot right-of-way, we have many roads now that are 12. Probably some 10. What's the narrowest one you have, Russell?
Ditch
10?
to ditch,
10?
ditch to ditch.
Yeah, but how wide is the road?
Oh, driving surface?
Mhm.
Oh,
10? So that doesn't matter. We're spending money on roads every day that do not meet this specification. We're clearing them, we're salting them, we're maintaining them now. And if that's a hazard, then we need to fix those. So it doesn't add up. So I think we need to do this because it's the right thing to do. And these roads and the reason I say that, these roads are dead end. We're not going to consider, there's not going to be a speeding problem. They are 3 dead end roads there.
Now, you understand, when they become public roads, they are just that. People can drive up to your driveway, turn around in the middle of the night if they have to, 2 o'clock in the morning.
Yes,
They're public.
they're doing that anyway.
They're public, well, I'm just saying, and I'm not saying how I'm gonna vote. We won't vote on this till the next regular meeting of the court. But I have a real problem, I don't mind telling you. If we're not gonna follow an ordinance, then we shouldn't have it.
That's exactly my point, ma'am. That's exactly the reason I said what I did, because if we're gonna do one for one, we should do it for the other. And the main problem we have in county government is inconsistencies, and that's been the problem for years, and it continues to this day. And so I'm gonna consider that your road be taken in. That's gonna be my vote.
Well, I think on Quail Hills Drive, it may not be a problem having 40-foot right-of-way, except down below my place, I mean, it would be ditch for part of the right-of-way. And there's only one home facing Quail Hills Drive that it would affect, and that's mine, my concrete steps that go down. I realize that will have to be taken out. But I guess my house is about the only one that is real, that would be a problem on Quail Hills Drive.
Yeah. Josh, you got a point?
Judge, all we have to go by when reviewing the roads is the ordinance that's in place. And so when we look at that ordinance and look at your road, we can only judge, by that ordinance, which was the right of way being issued, really being the main concern. There's two different, the new road and the existing road, Judge. In the existing road, it doesn't address the condition of the road. That was one of the things that we talked about. It just mainly addressed the right of way. So I guess to say all that to say this to this court and to you guys and to anybody else, I've been doing this road deal thing, Judge, since I started working for the county. We've turned down a lot of roads based on that ordinance. So I'm not really sure where that places the road here is when they're going by this ordinance and looking at roads and making a recommendation to the court. I don't want to get the fiscal court in any kind of situation. I just want you guys to understand that the recommendations we make, it's ultimately for you guys. The recommendations we make are strictly on the ordinance that you guys have. So,
And that's not a problem. And I think the recommendation you made was accurate, but that still doesn't bind the fiscal court to follow that. And we don't have to do that. We can make an
No,
exception.
you can vote any way you want to.
We can make an exception if we want to.
That's
We
been the
have-
case all the way
They've-
along. and-
they've been made
And
plenty
we've
of
turned
exceptions
down
in the
roads,
past.
Terry. We've turned down roads, and
We
you
have.
know it.
Right. But we've taken some in too.
Well, maybe so. I'm not arguing the point. I said, we'll take that up at the next meeting of the court when we'll vote on it. But I want to get her comments in. And
Well,
now, Miss Jean, let me, your name, sir, because you're
Windhorst.
Chuck Windhorst.
Windhorst.
Chuck is here to speak in favor of as well. I'm gonna put you down as speaking in favor of as well. I want to get that in the record, Chuck. That'll be okay.
I only bought my property in '88, so I don't know all the original history.
Yeah,
when
I understand.
I was there, but I'm a fisherman, so I study old maps for
Yeah.
where roads were. At one time, Quail, what's now called Quail Hills, made a U-turn and came out, which is now Miller. And that explains about half of the turnaround on TVA land. It was, when they
A lot of
closed
the
the road,
old-
they just made a loop there.
Well, a lot of the old roads too,
And
Chuck,
that would be an
went
old-
down to the
old
river.
County road, yeah.
You know, a lot of the old roads went down to the river.
Yeah.
And once the lake was formed, you know, it changed the dynamics of that area for
They
sure.
had a county park, didn't they have a
Well,
park?
I don't.
Where
know if
this
it's a-
turnaround
I don't know if
is.
it's an official part. An old gentleman came down one time and I asked if he was lost, and he said, no, he was reminiscing. He said they used to come down and have picnics and fish in the creek. So,
But we just understood that the positive would be that there are no through roads.
Right, right,
Which would make it less dangerous
yeah.
if we can't reach the correct width or the right of way.
All right, thank y'all.
Judge,
Yeah.
do they have the option then to deed the additional property over and have maybe a variable on the two properties that wouldn't meet the 40-foot?
You'll have to ask Jeff
Yeah,
that
that'd
question.
be up to you all.
But it would
That's
bring
an
them,
option,
it would
yes.
bring them very close to meeting. Now, what about the cul-de-sac issue, Josh? Is that something that they could petition to be changed on the plat? Is it an issue with the fact that it's varying from the plat?
The plat showed the turnaround.
Right, right.
I mean, the turnarounds are in there. Now, they're not like cul-de-sacs,
Mhm.
they're like square, but they were platted. But now, what's existing, it seemed that they've already been taken up by the property owner.
Right.
So, I don't know if that's what to.
Well, I live, the front door of my house is on one of those turnarounds.
Yeah.
And it's just all gravel. When I have relatives come, they park in the turnaround,
Yeah.
but it's still there.
And I think Russell would have to tell you, what, I don't know what
Okay.
they need to look like, but one of the other things that the turnaround that's on TVA, I'm assuming that that would be the turnaround or the cul-de-sac. And one of the things we looked at, Judge, when we did walking trails at Rough Creek, well, we had to there would have to be some kind of permitting process with TVA. I know they drew a big rule with asphalt on a walking trail, so I don't know, but yeah, I think Russell could speak to what they would need and what those bills, because I know they're plotted.
What do you lack in requirement on the cul-de-sac? If they were to try to mitigate some of these issues, what would they need to do?
Which road is the first one to the left?
Quail Hills Drive is the one you turn into, and then immediately you turn into Sparrow Lane on the left.
Sparrow Lane, it had pretty wide driveways there and everything. So, I mean, being a little dead-end road, it'd probably work. The one on the right,
at the end of Sparrow Lane, it's not a circular with what you normally think of cul-de-sac, but there's an angle,
Right.
and it's 30-foot wide. And it goes down what looks like my driveway.
and the first little road on the right, that one right there would probably be the tightest one, as far as turning around.
Well, the problem also with that is when you pull in to turn around, then there's a real steep hill going down to Paul Hafer's house.
Right.
So it is awkward to turn around there.
So what would they need to do to mitigate that cul-de-sac issue?
Just try to give us the right of way to, to go in there and make it a little wider.
So to deed more right-of-way?
Right there in that one particular spot. I would say you'd probably have enough there to make a cul-de-sac, for the, no more bigger than what the roads are on the first road to the left. Then that other one going straight in, it goes right down to TVA property, and we would stop before we got to that cul-de-sac. I'm sure.
The Sparrow had plenty of room for a cul-de-sac. I'm not saying you have to have 40, but that wouldn't have enough room to be taken in. Turnaround like it was done on Red Oaks Drive, back in 5 or 6, is a lot smaller. With Alexander looking for a turnaround, there's plenty of room in Sparrow. But Pheasant Lane is really tight. And I tried putting a small turnaround, I think it was 49, 50, or 50, which has been used previously for. You really need someone's yard.
Okay. I mean, I agree with Terry. I mean, I think that there's something that we can do to make this happen for you. I think everybody here wants to try to make that happen, so.
I mean, there's no reason you couldn't get the 40-foot and take in Quail Hills. Looks like to me, that would be easy enough to do, and then you can see what you can do with those other areas. But wouldn't any reason to not at least take in part of it?
Is there school buses going down through there now, or?
There haven't been, but this past year, for the first time in a long time, we had 2 different families with children. But I think their folks drove them, didn't they?
If they weren't county roads, then I think they could have.
The bus doesn't turn in to our subdivision.
I mean, that's how it is on my road. You can't turn a bus around, and I live on a county road. I mean, you have to drop them at the end of the road, you know. Do you want to talk to your neighbors about the possibility of deeding the 40-foot? Or Terry, do you want to get with them and just see if that's something that they're willing to do?
I think Jeff and I met with them. I don't see any reason for that.
I think the
No reason
ones
for
on Pheasant Lane would feel like it was, too crowded, probably some on Sparrow Lane. But like I say, Quail Hills Drive, I don't know. There seems to be more room. They wouldn't mind giving up right of way on their yard for Quail Hills Drive. But some of the houses on Pheasant Lane are just very close already. I'm not sure.
30 feet in there's plenty. We've looked at it, Jeff and I've looked at it, and Russ and I have looked at it. 30 feet's plenty.
All right, any other questions? Thank y'all.
Thanks.
Is there anyone here to speak in opposition? County taking in Quail Hills Road, Sparrow Lane, and Pheasant Lane. Anyone to speak in opposition to the county assuming responsibility for Quail Hills Road, Sparrow Lane, Pheasant Lane? Third and final time, anyone here to speak in opposition to the county assuming maintenance of Quail Hills Road, Sparrow Lane, and Pheasant Lane? Hearing none, that concludes this public hearing.
I have a question, Judge.
All right.
Now, we're talking about taking these in under the existing road, is that what we're doing?
I'm not sure.
It'll be brought up as best they can to the standard, and it'll half paid by the county and half paid by the residents. That's what we're talking about. All right.
All right, let's declare the court back in the regular session. Any more business come before the court?
Motion adjourned.
I have a motion. Is there a second?
Second.
Meeting's adjourned.